Welcome to this explainer on Keighley Maxted vs. Durant. Today, we're stepping back into early 1900s England, right into a bustling countryside wheat market to unpack a classic courtroom drama centered entirely on secrecy, agency, and a broken promise. Let's start things off with a pretty provocative question. If a secret agent goes out and buys something for you, but they never actually tell the seller they're working for you, are you legally on the hook to pay the bill? Section 1. The Wheat Market Deal. Setting the scene.
Our story starts with an agent named Roberts. He's authorized by our defendants, Keighley and Maxted, to buy wheat for them at a specific maximum price. So, Roberts heads to the local grain market and strikes a deal with our seller, Durant. But here's the twist. Roberts actually agrees to buy the wheat at a higher price than he was authorized to spend. Later on, Keighley and Maxted find out about this, and surprisingly, they agreed to accept the transaction anyway. But then, they just never collect the wheat. This leaves Durant completely stranded, and he's forced to resell that wheat to someone else, taking a massive financial loss in the process. Now, what's really fascinating here is the massive disconnect between the two parties. The whole time they were negotiating at the warehouses, Durant genuinely believed Roberts was just buying the wheat for himself. That was his reality. But the actual reality, Roberts was secretly acting on behalf of Keighley and Maxted. He never once mentioned them. Which brings us to Section 2, the broken contract, a costly change of heart. Let's break down exactly how this fell apart. You've got an agent who goes rogue and overpays, completely failing to disclose his agency to the seller. Then, even though Keighley and Maxted, the principals, agreed to take the deal after the fact, they totally ghost Durant. They don't collect the goods, Durant is forced to resell, and he suffers a very real, very significant financial hit. He is left holding the bag for a deal he thought was rock solid. Section 3. Durant takes legal action, seeking compensation. Facing that kind of financial loss, Durant does exactly what you'd expect. He takes Keighley and Maxted to court. His lawyers build their entire case around a concept called ratification. Now, in contract law, ratification is a principal's subsequent approval of a contract made by an agent who initially lacked the authority to make it. Basically, Durant is saying, look, Robertson had the authority to pay that high price at first, but because you guys later agreed to accept the deal, you ratified it. Therefore, you're legally bound.
All right, Part 4. The courtroom verdict. The judge's logic.
So we step into the courtroom, and the judge meticulously breaks this complex puzzle down. Step 1. Did the agent enter the contract on behalf of a principal? Yes, secretly. Step 2. Did the agent actually disclose this agency to the seller? No, he didn't. And that leads straight to Step 3, which is the absolute kicker here. The judge determines that if the agency is undisclosed at the time the deal is struck, valid ratification is completely impossible. In the end, the courts dismissed the plaintiff's claim entirely. Why? Because the defendant literally could not ratify the contract, since the agent never disclosed his agency. Durant loses, not because the principals didn't agree later, but entirely because of the agent's initial secrecy at the wheat market. And this gives us Section 5, the undisclosed agency rule, the core legal principle. It all boils down to this brilliantly simple formula. Undisclosed agency equals no ratification. If you don't say you're acting for someone else right from the start, that third party cannot swoop in and legally adopt a contract later on. The fundamental takeaway here is that a principal cannot ratify a contract unless the agent acted openly on the principal's behalf at the very moment the deal was made. It's a cornerstone of contract law that still stands strong today. So, as you look at modern business dealings, you really have to ask yourself, if the true parties aren't fully disclosed on day one, can a legally binding agreement truly exist?